Let's take a look at the rulemaking process. The APA's rulemaking process range from unregulated to highly formalized, trial-like procedures. Rules relating to military and foreign affairs, agency management, personnel, public property, loans, grants, benefits, and contracts are exempt from APA requirements. Rulemaking on these matters may nevertheless be regulated by other statutes and or internal policy and procedure by agencies. The only APA requirement for procedural and interpretive rules is the publication in the Federal Register. Agencies can also make legislative rules in unrestricted fashion, other than required publication in the Federal Register, when they have good cause, meaning more elaborate procedure is impracticable, unnecessary, or contrary to the public interest. Informal rulemaking requirements are modest but subject to considerable amplification. Also known as notice and comment rulemaking, informal rulemaking imposes 5 requirements on agencies. First, they must either specifically notify affected persons or publish a notice of the proposed rulemaking, an NPRM, in the Federal Register. Second, the agency shall give interested persons an opportunity to participate in the rulemaking through submission of written data, views, or arguments with or without opportunity for oral presentation. Third, after consideration of relevant matter presented, the agency shall incorporate in the rules adopted a concise general statement of their basis and purpose. Fourth, after publication of a final rule in the Federal Register, at least 30 days must elapse before it can take effect, unless there's good cause, explained with the published rule, for it to apply sooner. Fifth, the agencies have to give an interested person the right to petition for the issuance, amendment, or repeal of a rule. If an agency significantly revises a proposed rule after receiving initial comments, it may publish a new version in the Federal Register to obtain additional feedback. Also known as rulemaking on the record, formal rulemaking is very elaborate, so much so that it can be counterproductive in terms of timeliness and efficiency. This is why the 1981 Model State Administrative Procedure Act avoids it. Federal agencies are also apt to dispense with it whenever possible, which is often. The APA sets forth the structure for formal rulemaking but does not require agencies to engage in it. Formal rulemaking is a quasi-judicial, trial-like process. Hearings, which are central to congressional lawmaking, are mandatory for formal rulemaking. A panel or specific officer, who would be an administrative law judge or similar hearing examiner, presides. The presiding officer or panel can issue an initial or recommended decision. Initial decisions become final unless they're appealed. Recommended decisions are automatically subject to review by the agency head or governing board or commission. The final rule, if any, is published in the Federal Register and takes effect as specified, after at least 30 days have elapsed to enable those affected to comply. In unusual cases, the agency, board, or commission may issue a tentative decision for comment by parties and possible revision. These provisions may be modified by whatever statute requires the agency to use formal rulemaking. Hybrid rulemaking was developed by some federal agencies, promoted by Congress, and until 1978, sometimes imposed by administrators by the courts. As a means of making public policy, formal rulemaking is informational and procedural overkill, whereas informal rulemaking is potentially inadequate in providing agencies with the comprehensive data and perspectives they need to formulate sound rules. The APA allows agencies to search for a middle ground that's just right. Most notably, they can hold public hearings in conjunction with notice and comment rulemaking and invite interested parties to participate or solicit their views in some other fashion. With wider information, the agency can build a more complete record and, presumably, a stronger rationale for its final rule. Hybrid rulemaking is related to a shift toward greater public and public interest group participation in administrative policymaking. Negotiated rulemaking was developed in the 1980s, also as a means of bringing rulemaking closer to the idealized legislative model. It relies on face to face negotiation among interested parties, including agencies, to formulate rules. Also known as regulatory negotiation, regneg, it gained full legitimacy via the Federal Negotiated Rulemaking Act of 1990, which amends the APA's rulemaking procedures. Regneg is considered appropriate only when a limited number of identifiable interests will be affected by a rule. The general procedure is for agencies to establish rulemaking committees after notice and comment in the Federal Register. Committees will typically comprise up to 25 members drawn from the agency, regulated entities, trade associations, unions, citizen groups, and other relevant interests. The committee should adequately represent all the effective interests. Its meetings are always open to the public.